Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath, and we're talking today about an issue that seems to be on a lot of people's minds, which is when can an employer discipline an employee for making a social media post of some type? So we're going to spend a little bit of time talking about that today. There are a lot of competing legal interests, and this has been in the news a lot. It's been a very high profile topic pretty much all over the place. So we're going to see if we can help shed some light on this issue, and hopefully for the employers who are listening out there, you come away with some practical guidance on when you should discipline for this and what types of issues you should be considering if this is an issue in your workplace. So Doug, Jen, who wants to kind of kick us off and think through some of the things on your mind that should play into an analysis of when an employer should discipline for a social media post?
Well, what a loaded question there, Pam. I guess in my mind, where it first starts, and candidly, I think this comes out of a lot of like Title VII, EEOC guidance and law. But kind of a preliminary question being, if someone has a Facebook account, Instagram account, TikTok account, pick your social media platform, and it's their personal account and they're putting something on that account. So fully personal, is that what we're talking about? Or has something this person has done in some way found its way into the workplace or had an impact on the workplace? And, I think if you are looking at a situation and the answer to that question is in any way, yes, then as an employer, you have to be thinking about these issues, right? And impact on the workplace could be anything from coworkers are friends with that person on the platform, have access to that person's post, saw something and people are talking about it at work. Someone complained about it at work. Maybe the person referenced or tagged the workplace or a coworker in the post. Maybe they were posting a video and they were wearing something that identifies them with their employer when they did the post. And those are just some examples, right? So there are any number of ways where someone is doing on their personal social media could find its way to having some kind of an impact on the workplace. And I think that's kind of where I start. Now, it's not to say that every time that happens, the employer has to take immediate and drastic action. But I think that is then a situation where the employer needs to at least get involved somehow, look at it, ask some questions, right? I think we'll talk more today about what makes sense to do, but it certainly is not something that an employer can simply ignore if it is starting to have some kind of tie or impact to the workplace.
Yeah, and I agree with all that. And one other thing to add is that, there's be certain situations, and we've seen, some cases where this has happened, where, an employee is actually making, offensive or harassing comments about a coworker on the platform. That seems like an easy one to me, right? Like that's not only brought into the workplace, but it's, behavior that's directed at a coworker that could have the potential to create a hostile work environment. So that's definitely something where employers going to want to take action.
Yeah, I mean, maybe the starting point is there is no one size fits all here. Like it's not going to be guidance from us saying always discipline based on someone's social media post. The first question is let's take a step back and think about the facts at issue here. So what is the post? What is the content? Not every post is going to be treated the same. There's going to be a lot of factors that come in. Is the post off hours on personal equipment, or is the post being made during work hours on work equipment? That could change it. I would add to the list, is it a public employer? Is it a private employer? That could change some free speech entitlement considerations. So those are going to be some questions that you're going to want to think about. And we have had people tell us about concerns they're experiencing with a post, but it's going to depend on, well, what exactly is the post? Who did that post reach? What did it say? Those are a few of the starting points for this. And, I think for some employers, the reaction might be, look, I can't monitor everybody's off duty social media posts. I can't do it. I don't have time. I don't want to be that employer. But as Doug alluded to, we do have some case law here in the Ninth Circuit that suggests there will be scenarios where a post impacts the workplace and impacts the people within it in a way that creates liability for the employer and an obligation to do something about it. And we wanted to talk a little bit about that case because it should be on everybody's radar. If you're an attorney listening to this, thinking through issues related to this scenario, you should definitely be thinking about it. This is a case from the Ninth Circuit. It's fairly recent. It's from a year ago in July, and it's called Okanowski v. Garland, and it involves prison in another state. So we've got some public employer considerations, and it involves some off-duty, after-hour social media posts that impacted an employee in the workplace. This involves an Instagram account that a number of employees were part of, were following, and an employee who felt like the content of those posts impacted her ability to do her job. It's worth a read because this is a very drastic set of facts. The types of messages that were being posted are very, in some cases, over the top. And the management response really was inadequate here. It seems like maybe that employer had an attitude of, look, it's after hours. If you don't like it, don't follow it. And the Ninth Circuit in this case said, no way, not good enough. That type of social media communication clearly impacted this employee, clearly was of the type that would run afoul of Title VII and could have caused safety concerns. Management's response was not adequate. Too much time passed. Complaints were ignored. A lot of great takeaways and analysis in this case that really play into, for me, the conclusion that in some instances, an employer will have a responsibility to take action, even based on an after-hours social media post.
Yeah, and I guess kind of going back to my opening comments, I think practically speaking, if you're an employer listening to this, if you have awareness of some social media post, because you're not just monitoring your employees' off-duty activity, it has gotten to a point where you need to do something. That something may be to look at the issue and determine that it's not an issue that the employer is responsible for addressing. But if the decision is to do nothing, I would say probably it should be based a conscious decision that it is not the kind of thing that the employer needs to be concerned about. Because if you are already aware of it, most likely it's coming to your attention because someone in the workplace has raised a concern or a complaint about it. And especially, like Pam was saying, if it's something safety related or, I guess, incredibly objectively offensive content. Again, if you're not necessarily a public employer, there just could be facts that really make it such that it is not kind of a no-brainer that you do need to be doing something to address the situation affirmatively, and you can't just do nothing about it or set it to the side and say it's not our concern.
Yeah, and social media, and really a pretty relatively short amount of time, I guess we're talking about 20 years now or so, but seems shorter than that at times, has become so ubiquitous that I don't know that we really even think about how, you know, how the analogies between it and kind of other kinds of speech, right? Like if someone standing in the middle of somebody's neighborhood shouted the things that were in social media that they're putting on social media out, so that everybody's neighbors could hear them, we might think about them differently. So I think it's important to take this in context. This is speech to the whole world, and if it goes far enough to affect your workplace, you got to figure out what you're going to do about it.
And I was just thinking, the case that Pam was talking about, one of the things that I found very interesting about the opinion in the case is that the Ninth Circuit talked about the fact that if you are friends on social media with your coworkers, that your coworkers have access to your posts and can interact with it during work hours. And it did seem significant and meaningful to the court. Now, I think prior to this case, just the fact that somebody could access or look at their, coworkers' social media during work wouldn't have necessarily put a finger on the scale of, is this really impacting the workplace? And I'm still not sure that it would be enough alone. But it was a very interesting observation and kind of building on what Doug was saying, kind of the ubiquity and how widespread social media is, that, we might be getting to a place where it just almost automatically is in the workplace if you are friends with your coworkers, which is I think a very, a different and maybe new way of looking at this that very well could be the new normal.
Yeah, or if you have just a public account, public accounts out there as well. Like you're just sharing something out into ether, that might be enough as well. Maybe.
Yeah, one thing in that case that is important, I would say, to anyone's analysis, when you're looking at whether or not you should discipline someone and you're looking at the content of a post, one question you should be asking is, does this content run afoul of one of our policies? That is definitely something you should be thinking about. If you listen to our podcast, we're going to tell you should definitely have a good set of policies, an updated set of policies. Do you have a social media policy? If not, maybe now time to think of one. If you do, and someone is violating that policy, well, that could certainly tip the scales in the direction of maybe it's something that you should discipline for. Again, it's a totality of circumstances type of analysis here, but that's something you should be thinking of. In the case we were talking about, the Okanowski case, there were several policies being violated. So social media could be one, your Title VII anti-discrimination, anti-harassment policy could certainly be another, and then your code of conduct. Presumably you've got an updated handbook, one that lays out what are the rules for the workplace. And if an employee is clearly violating one of those rules that they've agreed to follow, well, that could suggest that there could be something here that requires discipline. Again, we can't really give you these broad rules because it's going to depend on what the post is.
Yeah, it's just
something to be thinking about. Think about your policies.
No, I was going to tack on, when Doug was saying that, maybe it's enough to just be sending a post out into the world, I kind of thought, I don't know about that. But Pam makes a good point. Like if you have a high level, very visible representative of a private company and something they have posted is like harming the business's reputation, for example, that may violate a policy, may violate job expectations, right? So there could be situations where even if you don't have anyone in the workplace complaining, it discipline of some kind may be appropriate.
Yeah. And if you really are a high level employee and you feel like you need to say things that possibly could run afoul of a policy, you should maybe be asking yourself, should I be friends with a whole bunch of people at work? I mean, I think that's always a consideration for supervisors, right? I don't think that's a best practice if you supervise people to be connected with them on your personal social media accounts. But certainly if you're vocal and taking positions on things that your coworkers might find offensive, maybe you shouldn't be friends with your coworkers. Another thought, just an easy one to think through that every employer should definitely have on their list.
And I guess on the sort of the flip side, we've been talking a bit about, things that may trigger some kind of discipline. I suppose, if you are considering disciplining an employee, there also are some things to think about that might be countervailing considerations, right? So we were talking a little bit about the NLRB before we got online here. And essentially, I guess the National Labor Relations Act, which generally says that if you're an employee, you have a right to kind of engage in activity with your coworkers. It's called like protected concerted activity, where you can talk about things like your work conditions, your pay, the idea being that you are entitled to have those discussions in service of potentially, making changes or initiating discussions about changes. So, for example, if someone posted something, you'd want to go look at the content and see if it was of a nature that might trigger protections under a law like that. And there are varying standards that would help you do that analysis, right, to figure out if it is something that could be protected. The NLRB, the National Labor Relations Board, has said, social media engaging in essentially discussions in an electronic forum can count. So then you have to just go look at it, right? But if it's something that can be protected, that might weigh against taking disciplinary action or taking a different kind of approach to disciplinary action. That's just one thing, at least, to keep in mind.
Yeah, if you go back about 10 years, maybe, well, it's probably more like 15. Geez, I bet it is. I bet it is closer to 15 to 20, like Doug said. When we first started seeing more social media activity, employers largely have the same question they have now. It didn't look that different, right? It's just in the forefront in the media right now. But employers really, when this was first becoming prevalent, were saying, when can we discipline someone? And oddly, and somewhat unexpectedly, the National Labor Relations Board was the agency that stepped up and said, we're the ones who are going to lay out the rules on when social media activity, when an employer can discipline and when they can't. And a little refresher on that, because I think a lot of people had never heard of the NLRB and didn't realize that the NLRB does apply to both the private sector and the public sector. We think of it more in terms of when an employer has organized labor of some type, a union, but its reach is actually much broader than that. And over the last 15 years, largely depending on the administration, I suppose, we've had periods where the NLRB, you hear more about it and it's more active. And then we have periods where you don't really hear much about it. And we haven't heard much about it for a number of years. But they developed this test that's the one Jennifer's talking about, that basically said, look, employers, if an employee's engaging in protected concerted activity, you cannot discipline them. And even back then, the guidance was you better have a policy if you're going to try to discipline for it. So employees know what they can and can't do on social media. And if more than one employee is talking about a term or condition of employment, you can't touch that. And we were just sitting here thinking, is that still, the governing test? And I think it probably still is an important consideration for employers. We don't have any reason to think that test does not apply. We don't see a lot of NLRB activity in Idaho for sure, but you would want to think through the content of a post. Is it about a term or condition of employment? And if it is, you might want to be careful about disciplining for it. And what would that look like? Boy, I'm like struggling trying to think of what some of those early cases looked like from the NLRB. But I know things talking about safety would fall into that, talking about pay. I know there were a number of early cases talking about supervisors. Could an employee criticize their supervisor in a social media post? And the answer to that was, yeah, in some cases they can, if it's talking about supervisor activity that's impacting a term or condition of employment. So that consideration is certainly one that should be on an employer's mind too. I'm thinking about that. Another note I had on that Okanowski case, I had mentioned that management dropped the ball because there had been a number of complaints by this female employee that had not been appropriately addressed. And on appeal, the record was clear that some of the managers who received these reports had said things like, well, we actually thought those posts were funny. And I thought that warranted a little attention here too, because for anyone listening out there, that is not a great defense ever to have a comment that is possibly harassing or jeopardizing someone's safety. Humor is pretty much never a defense. And the Ninth Circuit really did throw the book at those managers in this case for being flip about someone's sincere and somewhat like objectively warranted concern about a post.
Yeah, say we were talking about that a little bit too today. A lot of, at least the things that are in the news now, but I think generally speaking, it's probably fair to say a lot of things on social media fall into more subjective light, right? Like different people can look at something and view it differently, right? And have different reactions. But I think along the lines of a lot of things, not even just social media, but even behavior in the workplace, right? Just the fact that someone could take a different subjective view, like finding something funny, isn't a reason to dismiss whatever the employee's complaint is and not address it or do something to get to the bottom of what is going on. And so in some of these cases too, the right answer might be that you have to look into it more, right? Before you can decide what, if any, action is appropriate. That may be as simple as, someone within the organization asking a few people a few questions and kind of doing an informal investigation, all the way to something more formal and doing an actual investigation, possibly even bringing an outsider in to look at the issue, especially if it's gotten to the point where, a sizable portion of the workforce is wrapped up in the situation. Sometimes having that independent, neutral, outside perspective is incredibly helpful in evaluating like the facts of what happened, more objectively, right? What are we talking about? And then looking at policies. And is there a policy violation here? If there is, who violated it? And then what's next? So.
Yeah, and I kind of had a thought that came to me while you guys were just talking, and something from this case. So under Title VII, when we're talking about hostile work environment claims, we have this sliding scale where you're balancing the severity of the thing that happened. So in this case, the severity of the post versus its pervasiveness. And the court in this case said something that made me think about a social media post is more pervasive than just a comment to somebody that somebody made. It said, social media posts are permanently and infinitely viewable or reviewable by any person with access to the page or site. So I guess my takeaway from that is because something can be shared and reshared and discussed and brought back in a social media post, maybe the comment itself doesn't have to be quite as severe as an in-person one-off comment would be in order to implicate Title VII. And that's kind of something I hadn't thought about before. And I think that's really interesting.
Yeah, it makes sense because how often would you have a possibly harassing comment made in front of 100 other people, right? And that's in this case that we're talking about. It was an Instagram account followed by more than 100 employees, it said in the case. So you think about it, if it's a comment someone makes in the work, people probably not going to be, hopefully, a supervisor, a coworker, so brash as to say something like that in front of 100 other people. But with social media, that's pretty easy to do. You know, you can reach that type of audience without too much trouble.
I was just thinking about how often as a poster, it might be easy to forget that, right? That, you know, whatever you're putting out there, as Doug said, to the world, may well have, it's like a pebble in a lake, right? You throw it into the lake, makes a small splash, but then over time, it can get bigger and bigger and ripples effect, right?
Yeah, and another thing to think about too that we're hearing about now in light of the Charlie Kirk situation and in light thinking about that case we've been talking about, and also going to loop in what Jennifer was just saying. You know, if someone were to come to you and bring a complaint and say, I'm very concerned that this social media post is impacting me, think about retaliation too, because that is always a concern in any type of Title VII case. And if your response to that person is to mock them or laugh at them, I mean, probably not the most professional response, right? But if there genuinely is some type of harassing comment, a comment that, you know, creates safety implications, that employee now would also have possibly a retaliation claim. If what you've done is made the situation worse by not addressing the complaint, but rather by somehow downplaying it or mocking it, that was definitely something going on in that Okanowski case. Again, comments by leadership that we think it's funny, and comments to this woman bringing a complaint about, you need to get a better sense of humor and you need to chill out, you know, quit worrying about it. Those things are not an appropriate response.
Yeah, anytime it's the person who's offended's reaction is somehow the problem, that's a bad idea. Don't go there.
Yeah. And I think in the Okanowski case too, the other thing that was persuasive to the court, I think, and significant, is that this person who was posting on social media didn't stop. The you know, the conduct that the employee was complaining about just kept going and going and going and going. So, you know, I would say to employers, like Pam was saying, you know, don't mock somebody. But even if your initial reaction is, hey, I have an easy solution for you, stop following that person. If things continue to happen and this person's coming back and saying it's still a problem, it's a worse problem, that's not going to be enough, right? You're going to have to do something more.
Yeah.
And what are most employees' reaction to that is, if I don't follow him, then I know everybody else knows it.
Yeah.
And everybody else is talking about it, and I don't even know what they're talking about. So I don't know that that's really ever a good
solution.
Response. Yeah.
Yeah, maybe it works if you're the only two people who are friends on social media in the workplace. But yeah, certainly if in this situation where you have like 100 other employees, you would be kind of the odd man out, not keeping tabs on what's happening.
Yeah. So, okay, well, those are some practical tips for maneuvering through these things. You know, just to kind of sum it up here, look at your policies. Is there something about that content that is violating a policy? You know, if so, you need to do something. I mean, and if people are claiming or complaining that it's impacting the workplace, you definitely need to give it an analysis. Don't just discount it and tell people quit following them then and move on. So think about your policies, update your handbooks, think about some supervisor training. Are the people on the front line your supervisors who are hearing some of the buzz about comments like this, do they know what to do? And like Jennifer said, one thing you don't want to do is some kind of knee-jerk reaction here. Like if there's a complaint, if there's a situation, hopefully your takeaway from our podcast today is there are a number of legal issues that could be at play here. So, maybe you need to slow it down a little. Maybe you need to investigate, but firing someone immediately because someone does not like a post, maybe that's a little dangerous here. How about a little due process, a little investigation to think it through? Of course, there are going to be some types of employees who maybe have some due process protections. And again, we talked about government employees, private employees, might be some different speech protections there too. And then finally, don't forget about retaliation concerns. All of those things play into the situation we're talking about today. So that's it today for Ground Rules. Thanks for joining us. We'll see you next time. And in the meantime, don't forget about our Law for Leaders book, our desk guide that leads you through a number of different employment law issues that employers face on a day-to-day basis. And don't forget about our training. We've got our Law for Leaders content. We can do custom training if you've got issues like this that your supervisors need trained on. And then we've got some recorded content too. Our whole goal is to keep employers out of court by learning these key issues that lead to claims and lawsuits. That's it for today. Thanks a lot. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Licensed attorney.